visa updates and also provide brief answers to your questions about UK visa applications, including EU settlement scheme and British citizenship applications. I will prioritize in this order live questions with priority for channel member questions and then comments on the channel. There are a lot of questions that are written in the comment sections of various videos. I'll try and address them with the latest ones, starting with the latest comments that have been received on the channel. I'll try to cover as much as possible. Secondly, if you stay throughout the live, I will be giving important updates throughout the live every 10 minutes or so. I have written down several updates from home office that I will be giving, and other viewers have benefited from a lot of previous lives, have saved on the cost of immigration advice, many simple questions that really bother them or even lead to application refusals. I've clarified during lives and people have been able to get help from all the answers that I have given in the past. So that's thirdly, stay until the end of the live. I will give specific on two important updates. One on update for healthcare workers whose sponsor has lost their license, number one. Number two, new way of investigation for skilled worker applications within UK. So these are 2 pointers that I will be addressing towards the end of the video. So if you stay throughout the live, it will be helpful. If you are interested in these 2 updates, healthcare workers where sponsors have lost the license and new way of investigation. Home Office has started a new way of investigation for applications for skilled workers filed inside the UK if they are switching from some other visa category. If you are able to hear me clearly, please give a thumbs up. My throat is still not clear, so I'm not doing these lives regularly, but I'll try to do my best. Secondly, who is this live for? I just want to set all the parameters and expectations right. Who is this for? Every UK visa has its own challenges. I will give you all the whatever answers I can within 10 seconds to 30 seconds, not detailed advice, just question answers which I can do in 1 or 2 lines. That will help you and it will take you one step forward in your journey on any UK visa that you are filing. And about me, I'm Sachin Sawant. I'm a UK immigration lawyer registered with the OISC at level 3. I do immigration applications, appeals with tribunals, everything. So advocacy and appeals summarily. And so all the pointers I have covered, what I had noted down. I will take some live questions. So Rahul, thank you for becoming a member. If you have any question, you can ask. I will be prioritizing members' questions. I'll take the live questions first. Idir, hi sir, does the WhatsApp chat is obliged in spouse visa? I understand what you mean. So I think Idir is asking, is it necessary to submit WhatsApp chat for a spouse visa application? If you have WhatsApp chat, then definitely I would advise you. It's not written in the rules that you have to give WhatsApp chat, but the onus is on you to prove that the relationship is genuine. So whichever way you can prove it, e-tickets of traveling together, meeting each other, photographs, emails, anything and everything that you can produce, you should. If you have WhatsApp contact with each other, then do produce it. The easiest way that most of our clients do is, if you have been using WhatsApp for whatever period, minimum cover 2 years. So if you have been using WhatsApp for more than 2 years with your partner, cover at least 2 years of period, you can send the chat of WhatsApp from either it's a Google device or iOS, whichever. Google search for it, how to send my WhatsApp chat history to myself. There is a way. You can send it to yourself and then you can put every month 1 page. So that is what is usual practice that we do. But if you have WhatsApp, then use it. If not, then yeah, you cannot make WhatsApp chats for the application. Okay, gorgeous music. I am on youth mobility scheme. I can switch my visa to skilled worker visa. YMS to skilled worker. Can you switch it? Okay, I'm not 100%, so let me check. To the best of my knowledge, you can. Yes, you can. Right. Appendix. I'll give you the answer in a minute. I know the answer, but I just want to confirm and give it to you. I don't want to give any wrong answers here. Okay. So, responsibility. Yes, you can switch. Yes, you should be able to switch to a skilled worker visa. Yeah, youth mobility scheme can switch to a skilled worker visa. So, yes, thank you. Ankit Puri, my skilled worker visa extension in July 2025. How early my company can issue costs? Your company can issue costs anytime. They can even issue it now, but then obviously we'll lose the time period that you already paid everything for. A cost is valid for 3 months from the date of issue for use for a valid skilled worker application. So they can issue you within 3 months before the expiry of your permission. Okay, gorgeous music. Yes, I'm Indian. Thank you for that information, Karen. I cannot view my e-visa as a notification after I did. It says you will be notified when you can view your e-visa. Travel outside the UK. Can I travel? Can't view my visa. So your BRP should be expiring on 31st December 2024. So which is tomorrow, I think. Home Office has made a concession. You can still travel. Don't worry about that e-visa situation, because all the carriers have been informed that they will be accepting even expired BRP cards, which have expired, which will be expiring tomorrow, even after tomorrow till 31st of March 2025. So you should be able to use your expired BRP card to enter the UK by showing your carrier that expired BRP if you are entering the UK on or before 31st March 2025. So that is Karen's answer. Where is your office? Can you give me address, please? Yeah, we have several locations in London that we work from. We are based in London. Currently, I am not in London. I am out of the UK. So it's Christmas vacation going on. I am with family outside the UK. Yeah, so we work from London. Most of the work is done virtually. I work from home. I have family commitments also. I have kids and everything. So mostly almost 95% of our work is done remotely, digitally, with cloud storage, emails, video calls. Like these video calls happen using Google Meet. Physical work is very, very less, like once in a year or so, I think. So everyone prefers digital. So most of our work is done digitally. But yeah, I am based in London. Hello Rahul, thank you for becoming a member. You can ask me your question if you have any questions. Okay, I have addressed all the questions till now. Till the time any live questions come through, I'll take the questions on the channel. So no live questions yet, so let me just take these ones. Hello Babakar, Merry Christmas to you too. Thank you very much for joining this live. Thank you for being a continued member. And if you have any questions about parent visa, I remember, if you want, you can ask me. Yes, I saw you become a member last week. Thank you very much. Do you provide genuine sponsorship jobs? I don't provide sponsorship. I don't provide jobs. I'm an immigration lawyer. Sorry about that. Okay. Okay, so I'll take the questions on the channel. Hi sir, please reply. My employer applied DCOS for 3 years skilled worker visa and I'm under 26 age. Does my application will consider as a new entrant or I am not visited UK before? Okay, the question is about new entrant visa. So this individual Sri Ram Harish has never been to the UK before, applying for entry clearance. So defined certificate is applied for 3 years for someone who is under 26. That is perfectly fine. Someone who is outside the UK coming to the UK for the first time, under 26 years of age, they can get up to 4 years of new entrant category. So 3 years of DCOS is fine in your case. Okay, live question. Ankit Puri. So my wife is on skilled worker visa, skilled worker dependent visa, her company offering skilled worker visa dependent to skilled worker. Okay, if she switch, will her clock start from zero? She's becoming dependent. Yes, her clock will start from zero again because she's becoming the main applicant. So she is a dependent now, but she will start her clock new for the 5 years of ILR once she switches to her own skilled worker visa. Erin, how can I prove sole responsibility for children? Child dependent visa, I'm on a skilled work visa, letter of refusal from home office says child custody and so on. Yes, Karen, I remember in the last live on 26 December also you asked questions on this matter. I think your application has been refused for your child. Mainly, so I'll answer with the what was the strongest evidence that Home Office is looking for. Your child is outside the UK, trying to join you as a dependent in the UK, dependent on a skilled worker visa. The biggest problem that you have is you cannot go to a judge unless you go for a judiciary, which is a completely different matter and very complicated and quite an expensive matter. So you only have admin review. Admin review is almost useless in your case, I can tell you. You can wait for that 12 months, you can test it out, but I don't think you will get any results. You asked about admin review also in the last live. Mainly Home Office is looking a third party confirmation. So the best evidence that you can give for sole responsibility is wherever your divorce has happened, in whichever country, if you have gone to a judge, to the judiciary system of that country, if a judge has confirmed this child A should be, I am giving sole custody of this child to the mother, to Karen, only then that is the best evidence that Home Office is looking for. Okay, so this is the one thing. I know the other options, there are lesser evidences, but it is quite at the discretion of Home Office. The rules are not very clear on this point. We have been arguing with Home Office on this. Home Office is still working on this sole responsibility aspect. They have not made clearer rules yet. They've gone back with all the information that we have given in this year. And on the sole responsibility, they are going to come up with some clarifications. It may take a year or more. I don't know how much time, but these are the challenges where only one parent is in the UK, the other parent is outside UK, and this sole responsibility is become quite a big issue for many situations similar to yours. So the best evidence, I told you, if a third party judge has confirmed, let's say they have declared the divorce, and along with that the child custody is also given to you, sole custody, then that is the evidence that Home Office is looking. That's the best evidence that Home Office will be happy with. I know other evidences that you may give letters or affidavits from your other partner confirming that I don't want the child to be with me, I am happy for Karen to take the child. Those don't work that much because at any point the other parent can renege on their promise, they can go back on their word, change things. So, and also under Section 55 of the Child Protection under the Immigration Acts, it is important for Home Office to protect the interest of every child. So that is the main reason it becomes very complex when one parent is outside UK, the other is inside, and the child is moving the child to the UK. Home Office is not happy unless it is exclusively they have like quite strong evidence to prove that this person has the sole responsibility. So I've told you what is the best evidence that they are looking for. If you can give that, Home Office will be happy with that. So Rahul, your videos provide a lot of insights. There is a small query I have posted. Thank you. I posted my response on the previous video just now. Can you provide a response? Yes, I will be taking on the comments, but yeah, first I will take the live ones and I'll go to, let me see if I can find yours. Where is yours? Let me see. Okay, finding comments on YouTube is a big challenge. Let me find. I'll try to find your question. If you can copy and paste over here, it will be helpful, or else I will try to find it. Not sure how best I can find it over here. Okay, yes, okay, your question is, I finished my master's degree in 2022. Before that, I got married, and since then, my partner and me are in PSW. Okay, now, so both of you are on PSW. She is on PSW, you are on PSW, separate PSWs of individually. Now she wants to pursue MRES degree. Will she get PSW now even though she is currently on PSW dependent visa? PSW dependent. Okay, she is a PSW dependent. Okay, can I stay as a dependent after my master's? If she has, so your partner has never got PSW main applicant as herself. She is a dependent on PSW. So she can get it. She has not exhausted her PSW quota, to call, if I have to call it. So she can get it if she has an eligible degree, etc., in her own right. And you can become a dependent of her if you are already in a relationship. It depends, because the way it would work is she would become a student for a certain period of time. You would have to become a dependent on that student. A student, make sure you check with the university, because not all students can sponsor dependents. If you are allowed to be a dependent on that student visa, depending on her course, it should be a thesis course or a PhD course or something like that. The university should know more about it. First, you will have to become a dependent when she becomes a student, you'll have to become a dependent on that. Only after that you can continue becoming a dependent on her PSW. I hope I have answered that point clearly. So she can get a student visa first, I think, yeah. Only after that, unless if she tries to study being a PSW dependent, you may not be able to switch and become her dependent, because I'm pretty sure the rules are very clear. At the point when the main applicant, that is, she is a student, yeah, it is complicated. When she is a student, you should be a dependent on her. You cannot be on your own PSW at that point. If you are a dependent, only then you can switch and become her PSW dependent. So technically that is the catch. So be mindful on that side. She did not do masters, my partner is on dependent visa. Yeah, I understood that. So she will have to go on a student visa, sponsor you as a dependent, her course, only then you will be able to switch and become her PSW dependent when she gets that PSW. Okay. If you continue on your PSW and she just studies on this PSW, you may not be able to join her as a PSW dependent. So you cannot become dependent on her PSW. That is my answer, if you understood it. Yeah. Okay. Where is it? Okay, next question, Ravi. I'm on ICT visa. My wife and son are ICT dependent. In 2020, my wife became main applicant general. General DV. Do you mean domestic violence, or what do you mean by DV? Is it tier 2 general you are referring to, main applicant? I'm assuming tier 2 general. Or my son changed her visa is on general DV. What is that DV short form? Can you complete that please for me? We completed, my DV definition is different, that's why. So we completed the linking of my son's BRP to e-visa, but UK website shows expired ICT visa details, not general. Very interesting. Can you confirm what you mean by that DV? Has she got her own skilled worker visa? What is that DV? Just give me that full form and I'll answer that question. I understood your question. Okay, Munawar Pasha, hi. When I was on a graduate route and I applied again for a student graduate route, applied for student visa using the graduate route BRP card. Okay, because I created an account when I checked my e-visa showing with the old BRP. How can I update? Yeah, you can update the old BRP to the new BRP. You have to go and update your ID document, update your UKWay account. Google search for update my UKWay account, log into your UKWay account. It will say what do you want to update. Update a new identification document. Click on that and follow the process and upload the details of your new BRP card. That's how you do it. This is normal, so this is how you do it. Okay. So time for an update. Let me give an update. As I promised, I'll give updates throughout the session. So the first update I have here is UK immigration ID check problem. So this is a common issue that we have observed. We have written to Home Office. I'm a member of Immigration Lawyers Association. We address this problems jointly, as we see all the clients see it, all the lawyers see it. We address and approach this. This has been raised to Home Office. So the problem is, if you are a non-EU national, so where you have a BRP card, in other words, so BRP or BRC card, and if you have updated your identification document and to a passport, that's what Home Office expects you, that because obviously BRPs will be ending now, everyone is expected to update the identification document to the passport. So if your passport is your main document, latest document updated on the account, or you used a passport to create your UKV account only. That is also possible. In that case, if you are trying to do an application from inside the UK, usually the problems are happening if you are applying for a skilled worker visa, student visa, graduate route switching to skilled worker visa. Most of these points based applications, skilled workers moving into all the points based moving into each other, graduate to skilled worker, student to skilled worker, anything, any permutations and combinations. So if you are trying to use the ID check app, you try to put your passport details, because that is the only number you can put. You have overwritten your BRP card details, or you only use your passport details. The ID check app is giving an error when you're trying to create that, and usually it says that there is a problem with your document, check you are using the correct document before and try again, something like that. So it's kind of making the whole process redundant. Home Office expects you to do it through the app, save time for going for appointment, but then now people have to go for appointment because that ID check app is not recognizing the passports for whatever reasons. So this has been raised to Home Office. I just wanted to give an update that we have not got yet an answer. I think this has been raised on 13th of December. So this is a common problem happening. Many people may be finding that there may be an alternative. You will fill up the form, go for an appointment and all that, but that is not the main intention of all this digitization of Home Office. The goal is not to go for an appointment and reuse your biometrics. So that reuse of biometrics is not happening, and applicants are forced to go for that because the system is not, ID checkup is not recognizing passports. It's just a problem. I wanted to highlight this. People are facing this, and Home Office are aware of this. We have raised this to them, not received any answer yet, but this is the problem that is happening. So I know people may ask questions on this, so it's better I'm just giving this update in advance. So Ravi, have you given me what is the full form of DV? General Dependent Visa. General Dependent Visa. Oh, how do I add that? So you were on ICT, my wife and son were on ICT dependent visa. In 2020, my wife became main applicant. General dependent visa. Became main applicant, okay. And so she became the main on a skilled worker, okay, I'm assuming that. And my son changed visa her to her visa. And okay, so son is dependent on her, not on you. Okay, understood. We completed the linking of my son's BRP and to e-visa, but EQ website shows expired ICT visa details and not general DV. Yes, understood. How do we check that this gets sorted? I think this is quite a, I know it's complicated. I know there are complicated statuses, mixed up statuses and all that happening. First port of call would be, if there is a problem, you know that there is a problem, you'll have to go through the UKVI e-visa web chat. So if you Google search for e-visa web chat for support, you will go through and you should find that page, and you have to do that web chat and try to solve it if you know there is a problem. But I'm not sure if it is a problem, because I'm not clear what I do understand he was connected to you. Now he should be connected to your wife because he became her dependent. But your e-visa is showing something different, or it is not showing. It shows expired ICT visa details. Yeah, so if it is a problem, so whatever it is still linked to you. You should contact that helpline and talk to them and raise it with them. Munawar Pasha, next question. Hi, when I was on a graduate route visa and I applied again for a student visa using the graduate BRP, I created an account. When I checked my e-visa, I was showing with the old BRP. I answered that one, sorry. Burugus Sumant, we don't need 38,700 right to apply. Skilled worker as of now, 38,700. As of now, we can continue with standard going rates. If you are applying for the skilled worker visa for the first time, the 38,700 base rate does apply. So that does apply. I'm not sure if you're already on the skilled worker route, if you are under the old rules. But that 38,700 still applies for any new applications. If you were already under the skilled worker route before the changes happened on 4th or 5th of April this year, then old rules apply to you. Abdul Rahman came to the UK on a care worker visa in June 23. Did not work for the sponsoring company October 24, I received a letter from the Home Office saying that I had 60 days. Okay. The country of switch my visa, which I would like to ask if my 1.5 year period will count towards ILR if I complete 5 years on the care worker visa. So Abdul Rahman, your question is you were on a care worker visa but did not work for the sponsor income in October. I received a letter from the home stating that 60 days leave. So I think from October, whatever 60 days they gave you, maybe December 31st, whatever that was, at that point your permission should have ended. Country or switch my visa, which I have now done. So you have switched your visa within the 60 days period. I would like to ask if my 1.5 years, it will count obviously because you did have permission in the UK. That does count towards your ILR. So that period does count towards your ILR because you did switch within that 60-day period and you got a new permission. Part developer, I'm switching from PSW skill worker, PSW skill worker. HR made a mistake on cost ledger, wrong category skill worker graduate. So GR graduate in tier 4/student. I'm switching to skill worker. Next one should be skill worker ISC liable. Yes, skill worker ISC liable, correct. So yeah, I think if they have done the student switch, then they may not have paid the immigration skills charge also because by default the cost will not charge them ISC because student switching ISC is not payable, but you are ISC liable. They will write to the HR, whoever is the level 1 user or the AO authorizing officer. Home Office will write and usually ask them to pay the ISC. I think that mistake may be ignored. I have never seen Home Office refusing for such small errors. It's just the wrong category that they selected, provided everything else is correct. Babakar, so the parent visa, does illegal entrant have effect on the visa? Illegal entrant aspect does not have effect on the parent visa. The main aspect or the main concern of the parent visa is you have a genuine and subsisting relationship with your parental relationship with your child, either sole responsibility or joint responsibility. So I know many of the questions that you asked, I know your facts of your case. I think if the child, you have responsibility for the child, you are doing anything, either living with the child and the other parent, or if you're not with the other parent, you are doing something, you are taking the child to the GP, to the school, to the nursery, whatever that is, or if the child is very young, say 2-month-old baby or whatever that is. So if you are, the healthcare visitor sees you taking part in the care of the child, changing nappies, feeding the baby, etc., etc. So yes, that is taking part in the child's life. So HR tried contact multiple times. I said, a business still no update. It's been 2 months. I don't think you should be worried much. I've never usually, yeah, this problem happens when usually the HR teams think that they know everything about the SMS. Usually they should take some advice before dealing with such matters. But anyways, I don't think that's the end of the world. They have done that small mistake. Home Office, when they pick up your application, they will write to them and ask for the ISC. Make sure you tell them that they should pay the immigration skills charge or they will refuse the application. Okay, so whenever that is asked, it will come to the usually the authorizing officer's email and they will ask for the immigration skills charge. That category selection will not matter in the decision making. Entered illegal 5 years ago relationship genuine with my British child. Yes, then you don't have to worry about it. If you have a genuine relationship with the British child, you are fine. I've done many such applications in the past, so I know these rules left, right, and center. I've queried many times. I've spoken to caseworkers also and caseworking managers through Immigration Laws Association. We've asked them what is that you are looking for, and we know what they are looking for. They want to see there is a genuine relationship and they want the confirmation from a third party, either a GP, any third party. It can be a school, nursery, GP. In your case, if the child is too young, maybe a healthcare visitor writing the letter saying you are taking care of the child, doing something, whatever you are doing, that those things do help. So Surajit, my visa expired in June. I became victim of visa fraud. My predecessor has made multiple mistakes, including skill worker and 2 times waiver. Because of that, currently applied FLR HR Okay, what should I do as the whole process was done online? I can't upload WhatsApp. I'm not sure what you mean by this. So your visa is expired and something has happened. If you have not filed an in-time application that before your expiry of your visa, either a fee waiver or the main application or a substantive application, visa application, then you may have overstayed. I don't think you have. From what you are telling me, you have filed subsequent applications one after the other, looks like to me. Was done online. I can't upload WhatsApp chat as evidence of fraud. Evidence of fraud. I'm not sure what are you trying to allege or why you are trying to show that fraud to Home Office. If you are expecting Home Office to give you some visa just because the fraud happened, I don't think that's how Home Office works. Anyways, you should speak to an immigration lawyer, take proper advice, give all the facts and see if there is a case. Home Office will not give you a visa just because some advisor has done fraud with you. You can go and file cases, whatever, a civil suit or complain against the advisor, whichever regulatory body it is. But Home Office doesn't have much to do over here. So that's, I'm sorry, but that is how Home Office will look at it. So I will tell you whatever, how Home Office behaves in such situations. But then you should speak to an immigration lawyer, take proper advice, see if there is any crux in the matter, there is anything that you can do. Only then, yeah, go ahead with some things, applications or what evidence you're talking of, WhatsApp evidence of fraud. I don't know what you mean by sending that to Home Office. Yeah, speak to an immigration lawyer and whatever the problem is, and take proper advice on that. So I'm planning to apply for a skilled worker visa as main applicant soon. Should my say I'm planning to apply for skilled worker visa as a main applicant soon. Should my wife also apply together with me? Is my dependent now or wait till my skilled worker visa is approved? So I'm not sure what visa your wife has. She can apply now because anyways, if she's becoming a dependent, applying for a skilled worker visa, if she becomes your dependent and she's on any other visa category, I don't know what visa she has, but any other visa, anyways, she is switching, so her account will restart anyways, unless she is a PBS dependent already. I think her account will also restart, so I think she should switch as soon as possible along with you, preferably, if not immediately after you get the approval. Shiraz of one, I was about to apply for FIR for ILR next year, but I was in India for 4 months without my UK without my UK visa. But my new visa and the gap between two visas is 4 months. Can I apply for ILR next year? If you're talking of a skilled worker ILR, you're trying to complete 5 years, no, you won't qualify. If you're talking of a 10-year long residence, then if your 4-month absence is within that 180 days of absence is allowed, 183 or whatever, then it may be okay. But you are talking of a 5-year ILR on a skilled worker, no, it will not help you. That gap is a break in residence. Bengajiola, while putting up my graduate visa, I mistakenly picked up yes when asked. Just 1 minute, let me see. I'll take that question. Let me start my timer. Start, okay, Benga. While putting my graduate visa, I mistakenly picked yes when asked if I paid for NHS medical treatment. So I was asked to produce evidence. You were asked to produce evidence means it was a part of the form, right? I later realized that I bought medication on the prescription of the doctor in the hospital. I bought in the pharmacy. I paid for it. I'm on. No, I don't think you have to worry about that NHS medical treatment question, since you were already had valid leave, either student leave or graduate leave. When you got that particular treatment, you went to the GP or wherever you went. That is perfectly fine. And those answers are not very relevant because you already paid IHS during that period. So I don't think you should worry much about it. Whatever you've written down, you can upload a covering letter saying, giving all the facts if you want to. But I think they are going to ignore that because they do understand if you paid IHS, you are eligible to take the treatment free. Paying questions, answers are completely irrelevant in that case. FCB UK, I would like to appreciate your sincere effort. It's wonderful. We wish all of us to have the best health and happy life. Thank you very much, FCB. Thank you for your good wishes. When I later realized that I bought the medication, okay, don't worry about that. I am currently on bail. Okay, so what is your question? Surajit. Raiden, hello. Thank you for everything you do. Your advice has been a source of comfort to my situation. I'm applying for a spousal visa for my fiance from the US. Fiance from the US, okay. I'm worried the minimum income requirement will go up. I don't think it will go up. To the best of my knowledge, it won't go up. Yeah, I don't know. I don't think so. It's not in discussion. Even we are trying to challenge and bring it down. So I think you may have seen my other videos where there was a consultation going on the MAC consultation, Migration Advisory Committee, where they're trying to see if that 29,000, which is the current MIR, if that itself makes sense. I think it may be pulled down or it may be maintained. So it's, I would say, from my experience, from what I know, I'm an industry insider, so I speak to other lawyers. I know what we speak to Home Office also. I speak to Home Office also. Overall, the political will is not to increase the MIR. That is what I feel from everything. In my opinion, that's my opinion. Sorry, but I cannot give 100% guarantee. 95% chances the MIR is not going up. That's what I feel, because yeah, I don't think Home Office is even working on that. So good luck with that. They may maintain it to what it is, 29,000, but I doubt whether it will go up to whatever they said last year. Okay, so okay, power developer dependent is working full time in UK, 40 hours dependent, also registered a limited company to get contract work. Dependent is working full time in UK. This cause an issue while applying for LR or PSW. PSW independent. PSW dependent. No, PSW dependent has full rights to work in the UK. Registering company doing business is perfectly fine. So don't worry about that. So yeah, dependents have full rights to work in the UK. Don't worry about that. PSW dependent, student dependent, yeah, all the PBS dependents have full rights to work in the UK. Yeah, should be fine. Rahul, hey sir, follow my query. Me and my wife visa expire this March. Okay, so you are PSW. I remember you. I read the previous comments. You are PSW. Wife is PSW dependent. Okay, let's continue from there. She enrolled into a thesis course. Okay, I work in a company and wish to continue job. Changing job to dependent visa after she enrolled is okay. Yeah, if her course allows a student dependent. So since January last year, only some student courses would allow, is the PhD courses or thesis related courses, similar to PhD. So master's courses with thesis or something like that. If a course allows you to become a dependent on that student visa of your wife, then become a student dependent, and then when she gets her PSW, you can become a PSW dependent. So that is possible. Can an overstay become dependent of a skilled worker? No, overstay cannot switch to any visa from inside the UK other than a parent visa, which is a 10-year route to settlement. That's an exceptional area. That's very similar to Babakar's case, which I was addressing earlier. Karen, I gave divorce certificate as well as sole custody from the court. Okay, I'll take your question. So my timer says it's the time for an update. So let's start. I'll give another update. Where is that? Okay. 24/7 helpline. Where is that one gone? Okay, so there's a good news from the Home Office. Yeah, I mainly give bad news also most of the time, but there's a good news on the e-visa front. So basically the Minister for Migration and Citizenship, yeah, they have confirmed on 17 December that what do they a specific 24/7 passenger helpline. All these e-visa issues, everyone is asking me questions here on the channel, everywhere. For the e-visa issues, we have been raising this with Home Office, even with the ministers and all, through whatever parliamentary lobbying we can do. A specific 24/7 passenger helpline is being set up to help those who are traveling after 31st December 2024. So someone asked a question before, I think your e-visa is not, whatever, you cannot, it's the visa is not updated or something like that. You asked whether you can travel, you want to travel. You can travel. I did answer that up to 31st March 2025. You can use your expired BRPs or BRCs. And further addition to that, from the ministers, it has been confirmed. A specific 24/7 passenger helpline is being set up to help those who are traveling after 31st December 2024 who are experiencing issues verifying their status. For example, expired BRB, whatever. You are stuck at the other end in your home country or whichever country you travel, you are trying to board the flight, but on the system, nothing is seen. So they have a special helpline that has been started which will work 24/7. Yeah, 24 hours, 7 days a week, who are experiencing issues verifying their status to that particular carrier, airline, train line, whichever that is, wherever you are trying to board to come to the UK. The number is due to be announced after Christmas. If you just Google search for 24/7 passenger helpline for e-visas after 31st, so when the number is due to be announced after Christmas, so you should Google search and you should find the number. I'm pretty sure, I'm not in the UK, the search may not come over here, but if you are sitting in the UK, search for 24/7 passenger helpline for e-visa issues verifying status. You should get that number and should go live. The number will go live on 9 a.m. on 31st December. That's tomorrow morning, 9 o'clock, running late until 31st March. So for the whole 3-month period, the number will be live 24 hours, 7 days a week. So any issues, you should call that number. If you're having verifying status at any airport, you are stuck where the carrier is giving you a hard time. Okay, so that's the next update. Okay, just 1 minute. I will take. Oh, Cortes Cortado, thank you very much for your. I don't know what this means. I think it is a super chat or something. Sorry, I don't understand YouTube much, but yeah, thank you for your super chat. I think that is a super chat or something like that. Thank you very much for supporting the channel. Let me answer. Where was I? I gave divorce certificate as well as sole custody from the court, yet the Home Office says I have not provided sole responsibility, sole custody from the court, and also consent letter from the father. Please, what do I do now? Oh, this is the second refusal. Get your documents reviewed by an immigration lawyer. Yeah, try not for, these are, I'm not trying to upsell my services. You can go to any lawyer, I don't mind, but these are complicated cases. Home Office gives a hard time with all this sole responsibility area. Get the documents reviewed by a qualified immigration lawyer. We do that. You can book a consultation with us or go to any qualified legal representative. Get the documents verified, whatever the refusal letter against the documents that you have provided. Something is missing somewhere. I know they are looking for something else and you are giving something like that, I think, or you are giving everything but they are making a mistake. Both things are possible. So Karen, my advice is either book a consultation with us. All the details will be in the channel on the description of this video and other videos also, or you can speak to any other immigration lawyer and get those things assessed, the refusal reasons and the documents that you are giving against each other. Only then, yeah, any advice can be proper, constructive advice can be given, and you can see what the problem is, where is the problem exactly. Sheikh Irfan, hello sir, I am on a healthcare visa from agency. If I am switch my visa in domiciliary care, so I need to start again 5 years, or can I continue? You are healthcare visa, you are a skilled worker visa holder. So whether whichever job you change to, you don't have to restart again. Your previous period does count. You will be skilled worker only. You are a skilled worker when you're a healthcare visa holder. When you're a domiciliary care worker, whatever that is, job code is, you are still a skilled worker. So your previous period counts towards your ILR as a skilled worker. Alexander Eden, thank you again for your advice. As long as MI does not go up, then I hope that we will be married in 5 months. Your words have really helped me to calm us down. So thank you so much. Yes. Yeah, thank you very much, Alexander. I understood. Yeah. So if you are getting married in 5 months, the other option is if you want to get married in the UK, and if you are meeting the current MIR, let's say I'm just talking of hypothetically, if you are worried about it going up, then I'm just trying to help. I do all these plannings for clients when I'm having consultations. So you can consider also getting your fiance on a fiance visa. You will end up with that extra fees of 1500-1600 pounds of that fiance visa, and then get married in the UK. So because if you get the person now on the current MIR as a fiance, the current MIR will apply throughout the stay. Once she switches to the spouse visa, throughout the extension, throughout the ILR, everything. So that is one thing if you want to lock the MIR. Yeah, so just throwing it out, anyone listening to this, that may help. Uh, Sheikh Irfan, if I change my visa from healthcare visa to other visa category, so I need to start again 5 years. Yes, healthcare visa and skilled worker visa are the same thing. If you talked about you are changing from becoming healthcare visa to a domiciliary care, that domiciliary care will also be under a skilled worker visa. That's my understanding of it. So that's why I said it will count. But then if you become some other visa, I don't know, you become a student visa holder or something, then yes. Anyway, student visa is not a route to settlement. I'm just taking hypothetical situation. But then usually any job related visas, you'll only jump onto a skilled worker visa. You won't go onto any other visa, I don't think so, from a healthcare visa. So your previous period will count. Part developer, do we need to declare income? Do we need to declare income from birth country in UK? I'm earning good money in my birth country, example investment. Do I need to declare in UK? I'm already filing IT in new country. Speak to a tax advisor. I cannot advise you. I know some part of the answer, but I don't think I cannot. I'm not qualified to advise you, so I would not talk on that matter. Benga, hi. Does the threshold to qualify one for sponsorship on care sector start from 12? The threshold to qualify one for sponsorship on care sector. No, I don't think so. There is no such 12 pounds. What do you mean by 12 pounds? Sorry, I don't understand that. Okay, thank you very much, Cortados, for your super chat. Let's celebrate first super chat on a live stream. I don't know how to celebrate, but Google says let's celebrate their first super chat. Thank you very much. That's how I can celebrate it. Abhiha, do you only provide online consultations? Mostly. I have a lot of personal commitments. I have 4 children. I do everything. I take them to tuitions. My wife and our hands are very busy, so I prefer doing everything digitally. Yeah. I do spend, yeah, so I'm very much family focused, yeah, that's why. But output is very high when I'm working online. Physically traveling and all that is just a waste of time. Online video consultations is the most preferred one. Everyone does that, uh, and that is the best way, I think, to go forward. Even home office prefers digital things. Our regulator prefers digital things. Everyone is digital now, working from home. Even home office case workers also work from home. So it helps us give efficiency in everything. Thank you, Karen. Yes, thank you, Hussein Rashid. I do provide in-person consultation in central London. That is for very specific clients who really want in-person, but the charging rate is almost 3 times of what the online consultations are. You can go and check. It's on the website. If you check the channel link or channel description, there is a website. You go on in-person consultations, you will see the fees and all. So yeah, I do very less consultations, but then yeah, that is the pricing. The costs are also quite high. It's 3 times the normal. I think it is about 3 times or so. That's my normal charging rate. But the online ones, video consultations are reduced considerably. Just that I have work-life balance. Okay, Hussein Rashid. If I have tourist visa for Belgium, I enter to Belgium after 4 days. Go to Spain, can Bulgaria, I'm in Spain, my visa valid. I cannot advise on any EU. I am only a UK immigration lawyer. Sorry, I cannot answer those points. What is? My company applied for my DCOS 3 months ago. 3 months ago, the Home Office asked for further documents. Yes, normal. My company is the Shell. It is quite common. Home Office is asking a lot of questions for all DCOS requests. Yeah, that's what I've seen. Unless it's considerably high paid jobs. So we deal with sponsorships, we manage sponsor license for some corporates also, where salaries are much in the higher zone, over 70k, 80k, 100k, or even 200k, and all of that. In that cases, usually questions don't come that much. I've seen that. Or IT related jobs which are quite complicated, digital transformation and all, they are paid considerable sums. But other than that, any salaries between 30 and 50k, between that 30, anything between 30 to 50k salaries, home office is asking considerable questions. That is normal. It is taking time. Unless they have refused, it is still pending. Remember that. Don't withdraw the application and refile it. Home office has told us. I have made another video where I have informed everyone that home office wants not to withdraw those decisions. Let the home office process it in as they've received it. So they will be processing every cost request, DCOS, UCOS, whatever that is. It is normal. They are taking some time. It depends on the job code. It depends on the industry. Sometimes some industries are high risk, retail, etc., etc. Your company is Shelling Ringwood. What business is that? Shelling Ringwood. Interesting. Okay, I will give some other update. Okay, Shelling Ringwood. What does that mean? Yeah, it is normal. Usually, home office is asking many questions. Some people say, okay, so it is normal courtesy. They will ask all these questions, and your employer should provide all the answers what they ask for and wait for their decision. If it gets refused, they can apply again with further information, everything. There is nothing stopping them to apply again. Child grant 10 years long residence, appendix long residence 11.3. The applicant must have had permission on the current immigration route for at least 12 months on the date of application. What does it mean? What does it mean? You are asking me to interpret the immigration rules. If you have some specific questions, please ask them. I'm not going to go and explain I know the answer, but it will take a lot of time for me to explain. But summarily, the latest leave that you have, so let's say you are currently on a skilled worker visa, and that is your last year before applying. The latest leave you have is skilled worker. On that skilled worker permission, you should have been at least for 12 months. So that is what I can explain in simple terms. Per developer, what are the reasons top that may reject from PSW to skilled worker visa? Minimum salary already met. Everything should be genuine. That is the main reason where home office does refuse applications. And I'll give the next update. I think that may answer. Yeah, wait towards the end of this video. I will be giving that update as I have promised on new way of investigation of skilled worker applications inside UK. So that way Home Office may start refusing applications. There is a new way of investigation they've started. It's a fairly new one that I have seen. So that may answer your question part, but that is coming towards the end of the video. I cannot give the suspense out. What is, I am a support worker. Yes, you are a support worker. Yes, all these questions will come. Support worker, definitely. It's a common in that industry. It is common. They will take some more time. It may take up to 3 to 6 months or so for that cost that has been applied. It is normal. They are basically trying to see everything is genuine, because a lot of fraud and all this has happened, all this support work area. So they are assessing mainly the your sponsor, whether they are genuine or some wrongdoing is happening or something. That's what they are trying to assess, whether they really have work for you or they are just going to sell the visa and move on, something like that. So it is normal. They are doing all this research in that sector. Can we ask our MP to reach home office? It's 2 months, so still no received top up. Still no link received for top up IC payment. HR made category selection mistake. How to speed up? You file under the standard process, right? So it would take about 8 weeks usually. If in 8 weeks decision is not coming, then I don't know what MP is going to help on. MP, they just have a channel where they write to home office saying, please provide an update. They have another separate channel. We use that sometimes. But then I don't know what is going to happen in your case. You can use the MP to try to check the status, to follow up with home office. Uh, yeah, if that helps you. That's just one way of following up. Visa expire in mid-Feb. Yeah, but you have filed an in-time application, so it doesn't matter. Visa expire in mid-Feb. So you filed before the expiry of your current permission, so that's perfectly fine. Okay, all the live questions, I think I have handled them. I will take the questions on the channel. I'll give another update. Where was that one? Where is that one gone? Where is the third? Sorry, my updates are lost. Where is it? Where is it? Okay, scams of these agents. New scams that I'm hearing of. These scams just follow back to back. First the skilled worker, all these care worker scams, and then all these further leave to remain application scams. I've made so many videos. I just waste my time explaining all these scams now. So another new scam is I don't know, the students who want to buy time, live in the UK, or graduate holders or skilled workers or whoever that is, points based application holders, agents, all these consultants, don't fall prey to them. They are trying to file all these EU settlement scheme applications for pre-settled status. They are putting some fake documents. I've heard all this. This is just coming to me from different channels that I'm hearing. So I'm just updating everyone. Don't fall prey to it. EU settlement application is not for students who want to buy time, skilled workers, or graduate route holders who want to buy time. Those are into the EU settlement scheme. It's completely different. Uh, I think I've heard some agents are filing these applications for students or whoever to buy time. They are promising some wrong things, taking the money and filing these, but it is kind of a fraudulent application if you don't have any connection with any EU national, and so the agents are just attaching any EU national's documents to your application saying you are the brother of this person, you are the boyfriend, husband, partner, whatever that is, and trying to file these family member applications. You will be in trouble. The automated system may give you the certificate of application, may allow you to work in the UK for 3 months, 6 months. Maybe in 6 months, definitely Home Office picks up these applications and they will refuse them. But it is a very big black mark on your case. I don't even have time to make another don't ruin your life by falling prey to this EU settlement scheme applications that these consultants are filing on your behalf. Don't fall prey to, I know everyone wants to continue living in the UK, better their life, but this is not a solution. Home Office has very advanced system nowadays. Everything is tracked, everything is digital. All these fraudulent applications, frivolous applications in Home Office terms, frivolous applications, when tribunal judges look at it, they look at it, how many frivolous applications have you made? That's what judges say whenever we go to the tribunal, when we read the case summary and all of that. They try to see whether you are a good character person. So if you file all these nonsense applications just to stay in the UK, work for 6 months and all of that, it is bad on your record. Home Office is not happy, judges are not happy, no one will help you in future. So don't fall prey to this. This is a new thing that I've heard, scams of agents, consultants filing these EU settlement scheme applications of people who just want to buy time. Yes, you do get that certificate of application. Your right to work check will come positive for about 6 months or so. After that, they will ask for further evidence and they will refuse it immediately after that. So that is fine. That's the update that I wanted to give. Shahid Khan, I was on a student visa. Okay, 1029. I was on a student dependent visa since April 15 and moved to skilled worker visa. Okay, I will continue this live for about 10 more minutes. So just I will take these questions. I was on a student visa plus student plus dependent visa and moved to skilled worker visa. Moved to skilled worker visa. Yes, you will have to wait till July 25. Yeah, so that is the interpretation of the question that you asked me. So Shahid, yes, you will have to be 12 months on the skilled worker category because you just joined that category. Before that, you were on a different category. So you'll have to be on the skilled worker category at least for 12 months before the date of your ILR application, 10-year long residence. Gul Rahman was sentenced by the magistrate to 140 hours community service by touching without consent. Will the subject match submitted EU settlement scheme application? The 140 years community service is usually it is out of court disposal. It stays for 3 years for citizenship. I don't think it should affect. It's quite a minor offense and it's an out of court disposal. So if you have a genuine EU settlement scheme application, so I don't think that should affect. ELS Limited. Good evening. I got a mail from UKVI that I can't switch my study to a skilled worker visa. My study to a skilled worker dependent visa. In order to confirm acknowledgement of this rejection or provide additional info. Yeah, I think you have not completed your studies and you're trying to switch to skilled worker dependent. That is not allowed. So I think that's how I understand it. If you completed your course of study, then you can switch. That's what I know from the rules. ELS Limited. You cannot switch if you have not completed your course of study. You'll have to go back to your home country, apply for an entry clearance as a dependent. You cannot switch from inside UK. Care and course assigned in Jan 23. Work date starts December 22, Jan 23, and end October 26. I don't understand how many years course is that. Course assigned Jan 23 and work date December 20. Okay, December 22 and 26. I don't understand how many years course is that. Sorry, I don't know why do you need that. You should have already got the permission. So mainly you should be concerned more with the permission aspect, because for your ILR and all the permissions count. But then December 22, 23, 24, 25. So 3 years and what is that? 3 years and 10 months? I think that is what it looks to me. The course period, work start date and work end date. Approximately 3 years and 10 months or so, I think so. Sheikh Irfan, so my last question, if I change my visa from healthcare to restaurant or warehouse visa, etc., so I need to restart again 5 years because on my healthcare visa, also skilled worker visa. Whatever those visas you are referring to, restaurant or warehouse, wherever you're going to, it will be a skilled worker visa only. There are no different categories of visas for restaurant or warehouse visas. So your previous stay will count towards your ILR. Okay. So no live questions, nothing is coming through. How long is the live? 1 hour now. I've answered all the questions. So I have dealt with these 3. Okay, always can you please comment as to whether it is better to try for Ireland instead of UK, considering it is quicker to get PR in? I don't know Ireland visa laws, sorry, so I cannot compare that against UK laws. Sorry about that. UK laws are too much for me to study at the same time, so I don't know anything about other countries' immigration rules. So, okay. I'll take some questions on the channel for some time, maybe 10-15 minutes or so. Thank you very much. Thank you, Shahid. Okay, so yes, I answered. I'll take some members' questions if I can find them. I've answered this one. In December, does it take more time to get decision? Usually it should take, yeah, it does take more time, but just 1 or 2 more weeks, not that much. But usually Home Office will deliver within the service standards, 8 weeks, I think so. It does take slightly more. We don't get decisions around the end of December because many of them are on leave and all, but not that much, maybe a week delay or so. Okay, there's a member, Harsh. I've answered the previous question. So in the previous live, I think I have answered his question. He applied for FLR. So this is a common problem that it has been happening. Is it important to apply for e-visa? Yes. Lazy one. Thank you very much for the super chat. Is it important to apply? Your question is for e-visa. Yes, you should apply for an e-visa. That's what I would advise, because after 31st March, it will more or less become compulsory. They are not going to keep on extending this. The e-visa system is continuing. I know people may talk whatever, but we know for a fact Home Office is not giving up. This is going to go ahead. Everything is going ahead as normal. Some concession has been brought to allow use of expired BRPs on all till 31st March for 3 months, just to help out people. But after that, it will be e-visas only. They may extend this concession 1 or 2 months here and there, maybe. I don't think that may also happen, because 3 months is a good amount of time. They will be covering up all their problem areas. So you should get your e-visa. We cannot conclude your application networks because your sponsor needs to pay ISC fees. Yes, your sponsor needs to pay ISC fees. So what is the problem? They should have usually sent a link to pay the ISC fees. It follows that with after that email they will send a link to pay the ISC fees also. I got a job as a support worker in the UK. I have experience in this field. The company applied for DCOS in October, and in October and November, additional documents were requested. Okay, since then I got no answer. November, yeah, wait for some time. They will take time. Usually 3-4 months. Yeah, so from the date of the DCOS, and those automatic requests go out now for those sectors, which sector you applied. So definitely after 1 month, so you applied in October, in November the additional request came. That's also quite automated. Everyone is getting those requests, and once that information is provided, then it goes and sits in the queue and someone will pick it up. So yeah, and a lot of applications are filed in that area, so they have quite a long queue and they are cautiously treading these waters. A lot of frauds have happened in this area, so they are very cautious. So they will be checking each and every application, and they will check it. It's not that they are just going to ignore it and leave it there. Whatever a decision will be made on it. I think 3 months on a higher end from the date the information was provided. That's what I think. Sheikh Irfan, I'm continuing 5 years. If I am go any skilled workers, it's not matter. I'm go visa, but code exchange. Yes, you are still eligible. I understood all your questions till now. You will be on skilled worker only. The code doesn't matter. The codes can keep on changing. But I have a settlement status. Still, do I have to? Yes, settlement status. Do you have EU settlement scheme status? You should already have the digital status. You don't have to create a UKVI account if you have EU settlement scheme. If you have indefinite leave to remain under the British immigration rules, then yes, create an e-visa, as your BRB will be expiring now. So yes, lazy one, create your e-visa. Pardon, after email, we cannot conclude your application because it's been more than 1 week. No link received in after multiple emails, follow up by chat, ICD email, business email. It's quite uncommon. Usually they do send because they just want to take the money and conclude the application. They're not going to keep it on hold. It's quite a weird one. Maybe, yeah, push it through the MP, speak to the business help desk. I think your HR should call the business help desk, give them the SLN, sponsor license number, and tell them the problem. Usually the business help desk is quite helpful. Yeah, that's what I would advise. For us, December visa fill out of UK 9 December, decide now I'm waiting. Sorry, I really did not understand the question. December visa fill out of UK. So out of UK, file some December on 9th of December. What visa was filed on 9th of December? What visa is that? Spouse visa, skilled worker visa, student visa? If you tell me that, then I can tell you accordingly the processing timings. Sheikh, do you love you, sir? Finished my problem. Thank you. You have lots of patience. Thank you. Thank you, Sheikh Irfan. Yes. Anyone who's getting any value in this life, definitely consider becoming a paid member. Almost all the things, whatever YouTube gives, it goes into donations and all. Yeah, so, but yeah, it helps the channel. It helps YouTube to promote the channel as well. There is some 199, £2, whatever those nominal memberships are. It gives you early access to some videos, some whatever priority on questions and all of that. If you are getting any value, you definitely save hundreds of pounds on this. Just consider getting some paid membership, £1 or £2, whatever that is. I don't know. I just make it once and leave it there. Okay, so Parth, they called business help desk. They told to email ISC team. Every HR calls, same response. It's weird. Yeah, I know it is you're just stuck in a situation. We have our internal contracts, so if that's the reason we always advise, and people think, why do I need a lawyer? So this is why you need a lawyer. If you have the lawyer from initial stage, you cannot take in a lawyer at a point. For example, I would not advise you take a lawyer. It will not be add value much at this stage. That's why it's better to take the advice initially and do the things correctly. If not, at least take representation, at least advice or something. I'm not saying that you have done something big mistake, but this is the one of the reasons anyone who is seeing this live after recording and all, that's why at least take consultations, because these are quite big mistakes. If this was represented by us, I would have just written to a senior in the home office. Within 3 to 4 days, it would have been sorted. I know that. We do that. We don't use the seniors' emails just like that. But yes, something like this nonsense happening where you just need a payment link, which you are not given by someone. I'll just write to some senior, within 1 or 2 days an email link will come to me. I know that. So this is some nonsense. It happens. Things fall off. I know that. They deal with a lot of things. So, but that's why this is where it helps. Things fall off usually 10% of the times with home office. I know that out of every 100 applications, 10 of them something will break somewhere. One of the examples is you're not getting that ISC payment link. You made some mistake, but then the rectification is becoming challenging. So, but then yeah, try to escalate it to the business help desk and all of that. Try to do it those ways. That's my only advice I can say. Study visa interview 23rd December. Can you do this? Yeah, so you applied for student visa and your December interview was 23rd of December. Maybe after December, in 2 weeks or so, they should give you a decision. But then there are many holidays in the UK now, so maybe at least allow them till maybe 10th of January or so. That's what I would say. Can you do this now with your help? It's a difficult one to interfere in that cases. Yeah, we don't like to interfere. Home office doesn't like it. It's weird. We have a good working relationship with home office case working team, and yeah, so I know that it's nobody likes when you point out that you are wrong. So if unless it is being represented by us fully since inception, just taking over and trying to push them, yeah, I would not take such a situation, because things have been messed up. It is your mistake in the first instance. So then blaming home office for not doing their some part of the job is, yeah, sorry. It is difficult for a legal rep to enter at this stage and just argue when, yeah, initially even the sponsor had made some mistakes. One lazy, I have EU settlement scheme ILR. EU settlement scheme ILR, if you have it, you have EU settled status. You should already have a UKVI account. You cannot have a UKVI, you cannot create an e-visa now. You already have the UKVI account. When you applied for the USS ILR or even the pre-settled status, you had the same account. Through that account only you have, that's a UKVI account. Through that account you made all your applications, your civil status application. When you got the approval also, your digital status is over there. So whenever you put your passport number, your date of birth, then it sends you the code and you check your status. That is your e-visa. You don't have to create any other e-visa. You have EU settlement scheme settled status, so you are fine. You don't have to create any visa. You guys still have to do, because I have to try. I have tried on it. It dates wrong document. No, you don't have to log into your EU settlement scheme login. That is the back end of that shows your status. That's what it is. You already have a UKVI account. Don't create another one. Thank you very much for that super chat thingy. So only way now is to wait. Yes, and escalate it through whichever channels you can. That's what I would say. Because if you engage a lawyer, they have to redo everything from start, and the costs would not be commensurate with that. So it would be almost a full representation cost. That's the reason you've done all the things. Engaging a lawyer, you will end up with considerable cost as good as the lawyer is doing the application. So if you are okay with that, maybe a lawyer may engage with that. We may also engage if you are okay to pay the full service charges or something, but then yeah, it may not be cost effective for you. Thank you very much, lazy one. Thank you. And what was the next one? So where am I? Okay, I've tried to answer. I'm just trying to get any members questions. I remember I had some members. Shakur, thank you. Do you conduct such sessions frequently? I don't get much time. I'm usually busy. I'm on holiday. That's why I'm doing this quite frequently now. But usually once a week I do it. Once I'm back uh, around 8th. 8th I will be back, I think. From the week after 8th I may do one session. Yeah. Every week one session I try to do it. But now I'm on holiday, so I have some free time. Yeah, I'm working less. Yeah. Okay. Okay, I'm trying to answer a member's question. So Bilal Shaukat, I will take that live, but this one, I got my first skilled worker visa in 2023. Now I want to change my employer. Does the new salary threshold apply on me? No. If you got the first skilled worker visa, Bilal Shaukat, thank you for becoming a member. Firstly, uh, you got your first skilled worker visa in 2023. Old rules apply to you. New salary threshold doesn't apply to you because you are already on the skilled worker visa before 4th April. You are right. I'm here on, I want to start my business. Can I start my business or not? Starting a business is a very complicated area. I'll briefly answer this question. Uh, Usually, I know that in that home office, somewhere on that page, it says for your own business. There's just a one liner. Nothing is written in the immigration rules of starting a business. Overall, home office and our position as lawyers, even my position is that skilled workers cannot start their own business. Summarily, I will answer that. I will not go into the details. So those are the two answers that you asked. And Bilal Shaukat, so the new salary thresholds don't apply, but the minimum salary will be, at the time you applied before the changes was 26,200. Now minimum 29,000 salary threshold will apply whenever you are extending or applying for ILR. So how long home office is taking to decide on naturalization? About 3 to 6 months time for naturalization applications. Okay, and what else I have? Any other questions? Okay, I've answered all the members' questions during the live. Not to bring parents to UK once I'm a skilled worker visa currently on PSW. No, you cannot bring parents on UK on the skilled worker visa or PSW visa. Yeah, but my friend got visa new entrant route for 3 years. He already completed 2 years PSW visa. He's saying after 2 years he renewed the visa again for 3 years with a threshold of 3,900 after 2 years. Yeah, so what is your question? I know he's saying that. What is that you are asking? Can you clarify that, please? I understood everything. Okay, this is done. Okay, so we are towards the end of the live. As I promised, I will answer those questions. I'll give those two updates. Where are those updates? Are they here? Are they here? Okay, these ones I have done. These ones I have not done. Okay, I was approved visa. My advisor made second fee waiver application, which is not allowed by Home Office. Then they granted me bail because I had on applied skilled worker application going after 2 months. Yeah, so what is your question? You are on immigration bail. If you don't have any other family route basis, you won't be able to switch into any other visa application being on bail. You are already an overstay from the date they put you on bail. You should leave the UK as soon as possible after they put you on bail within 14 days. I know people don't take my advice, but this is what you should do. You can take it or leave it, but this is my advice. Don't just continue living in the UK unless you just want to stay as an overseer for the next 20 years and then file the applications. Yeah, I'm on FLR. Can I apply skilled worker visa? You're on FLR. What does that mean? You just filed a further leave to remain application. It is not decided. You may be able to vary it, but it really depends. Yeah, if everything was done in time and all of that, yes, you may be able to switch to a skilled worker visa. So, two updates that I promised. One is about the update for healthcare. Okay, this is the last one, and then I will give the update. Mira asking me, how likely do you think an increase in salary thresholds for skilled worker visa at this point? I don't think there is anything that is in discussions for skilled worker salaries to increase. They've already increased it to the extreme now. So, okay. So I'll give these two updates as I promised towards the end of the live. The live is coming to an end. Maybe in the last 5 minutes, I will give this update now. Update for healthcare workers. So the Home Office team has confirmed that 15 regional hubs have been funded. So this is about care worker visa holders whose employers have lost license and they just have the visa, they don't have work, nothing. So Home Office had promised. I know I have made several videos on these explaining that Home Office is going to do this. That's what they said. Now further update on it. If Home Office is not delivering on that, that is not my problem. I'm just trying to give these updates what we get from Home Office. But I know they are delivering on it. At least 10 to 15 people on the channel have written to me saying that they have got emails from Home Office. Sponsor's license has been cancelled, but they will contact the applicant in due course. They have not curtailed their leave, which they would usually do. So I know they are doing that. Unless you have any wrongdoing, you were a part of the fraud, you bought the visa, sold the visa, whatever you did, Home Office will curtail in such situations if they have any evidence or information to that you are a part of the fraud against immigration, fraud on immigration, then they may curtail it. But if you are a genuine applicant and your sponsor has lost license, you are a care worker, they are trying to work out, try to give you some options. So one of the things that they have confirmed they have started doing is Home Office team confirmed that 15 regional hubs funded by the Department of Health and Social Care to assist displaced workers are now fully operational. Displaced workers are the workers whose sponsors have lost licenses and they have care worker visas. Although different regions are managing things differently, the team confirmed, Home Office team further confirmed that they aim to contact all displaced workers. They are trying to contact all the displaced workers by the end of this month. So I think by the end of December, as I understand, directing them to the appropriate regional resource hub for assistance. And I think someone on the channel has also mentioned that the person has been contacted on the comment. Someone has written that, and they have been asked to contact some regional department or something. So it is happening live because clients are telling me on the comments in the channel. We understand that the full details will go live on the relevant gov.uk webpage in due course, maybe next month or so. The team further reported around 200 instances of rematching. So they're trying to match workers against work, against sponsors or employers. So 200 instances of rematching they have done so far. They have given work to 200 individuals whose sponsors have lost the license. However, no time frame was provided. They haven't provided any time frame for when cancellations will resume for this cohort. So they have not started cancelling their permissions. They have not confirmed when they will start the cancellations of permissions for these people. As we understand that their current priority is to support affected individuals. They are trying to support them and trying to get them, match them with employers. So some senior person in terms of rematching has in the Home Office has confirmed when a sponsor's license is revoked, the Home Office first waits for a short period to see if litigation action is instigated. So if the sponsor challenges and files a judicial review and all to get the sponsor license reinstated or something. If not, then Home Office writes to them saying it has been writes to the affected worker to try to match them with another employer. We understand that this will become the usual routine, so there should not be a separate displaced cohort connected to the same sponsor. In respect of helping individuals whose employer may still hold a license to sponsor, the team assured us that UKVI are more than happy to support those who find themselves in unfortunate positions, but emphasize that this support may be limited as the process is funded by DHSC, so Department of Health and Social Care, and administered by the regions. One concern the team noted was the sector's over-reliance on supplementary employment provisions. So this is the problem that Home Office says they have, likely due to flexibility and lack of responsibility for cost and sponsorship, as it leaves some individuals in a position where they may be working in supplementary arrangements. I know many of these care workers are working in supplementary arrangements. Even Home Office knows this, that might not quite fit within the rules. So you are only allowed the 20 hours additional work, everyone, whether care worker, skilled worker, whoever it is, 20 hours are only allowed in a skilled occupation, but they are working in other occupations. In spite of me telling everyone during through the channel, in spite of home office making the rules, and home office aware of this, that might not quite fit within the rules, which means they are in breach of their compliances. Given supplementary employment requires them to continue working for their sponsor, so you can only work the 20 hours extra if you are working for your main employer. But in these cases where the care worker, care home has lost the license, care worker himself is not working for the main sponsor, so they cannot do any additional employment. That's kind of a compliance breach. Home office is not happy with that, but yeah, they are trying to match. So this is the latest update. If this doesn't happen in your case, I am not the responsible person. I am just trying to pass on this information from home office. The second important one, skilled worker, new way of investigation from within UK. I know someone was asking me some questions. So new thing has come up. Home office is requesting a video interview of skilled worker applications which are filed from inside UK. It's quite rare now, but it may increase over a period of time. Some situations have been observed where HPI visa holders, high potential individual, it's similar to graduate route. So who is switching to a skilled worker visa where they've requested video interview of the skilled worker applicant. So just be mindful. I think they will ask the similar questions what they are interviewing for outside UK applicants for skilled workers. How did you find the job, etc., etc., your skill level, did you pay for the visa, anything and everything. So I think I have made other videos explaining all these points of what type of questions I think they do ask in these interviews. But then be mindful, inside UK also home office is starting these video interviews for skilled worker switching into skilled worker visa category. I don't think it happens for extensions or anything, but switching from other categories, from student, from graduate route, it will start into those areas also. They are doing it rarely, not much, but they've started it. That's what we've seen. So video interviews for skilled worker applications, this may become a normal for inside UK as well. Outside UK is quite common. So I was about to end this live. Many questions are coming through. Let me see if I can answer some. Rumali Modi. So all the updates I have given, I'll just answer some of them if I can. My PSW finished, then I apply for waiver, which was rejected. Then now, can I apply for skilled worker visa? You apply for, if your fee waiver was rejected within 10 days of rejection, you should apply that application, skilled worker. If it is beyond 10 days, then you cannot. You will be out of time. You won't have Section 3C leave. Free Albert, a new entry route for the 3 years. He previously completed 2 PSW, says that after 2 years, he can renew the visa for another 3 years. Yes, that is possible. So 2 years of PSW, 2 years of new entrant visa category, and then 3 years of experienced worker. That's how. Yes, that will work. Warrior Battleground, we are in PSW planning to start business. We have only 1 year exactly. Is it possible to start business self-sponsorship ourselves? It may be, provided everything is genuine. Genuineness is where home offices, I have done applications where graduate holders have applied for sponsor license, businesses and all. You have 1 year, you can start a business, test it, take it off the ground. If it works, apply for sponsor license and then do self-sponsorship. I've done cases which were genuine, and I have switched individuals on self-sponsorship, but they were genuine cases. Even I have assessed them before taking on them on. So yeah, it has to be genuine. It cannot be just to buy time or just to buy a visa. The business has to be genuine. Home office will assess the same things. Free Albert, my friend received a visa under the new entrant. Yes, I answered Albert's. Free Albert, Rumil Modi, I didn't submit my passport yet. I have appointment on 23rd Jan for, can I apply for skilled worker visa? I don't know what you mean by that. I didn't submit my passport. Yeah, you don't have to submit a passport now for anything. Can I apply for skilled worker visa? You can only, so Drumil, summarily I can answer. I know you applied some things, you applied fee waiver and then FLR, after that rejection or something. You should have Section 3C leave on the date of your skilled worker application. If you have that, get your situation assessed by an immigration lawyer. You can book a consultation with us or any other lawyer. Make sure that you have Section 3C leave. Only then it makes sense if you are submitting a skilled worker application. Yeah, once Mango Apple, you will not get your immigration health surcharge back. I'm sorry, but that is what home first rules are. So yeah, thank you very much everyone for joining this live. Yeah, we do provide consultations. All the details are in the video description. This video will go in the, I think it may go in the paid section or somewhere, I don't know. But yeah, so all the answers provided over here. Any for advice on your specific case, do book a consultation with us. We don't provide any free advice. We only provide paid advice. So if you want advice on your specific situation, hit the link in the description and book your consultation. Thank you very much.